I'm going to start with our hearing script, and then we'll jump right into it. So this is the December 8th, 2021 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati, and I'll preside over this hearing. This case is on, I believe this case was continued at our last hearing. Is that your understanding, Mr. Papademos? Mr. Owen?
Correct.
Okay, so this was continued from our August 26th, 2020 hearing. But for the purposes of, because there's been so much time between, we're gonna approach the procedure as if this were a brand new hearing. So I'd like to hear, obviously all of the changes from the past design, but really I'd like to see this presented as a new case and a new application in terms of the procedure of it. So the purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing, unless a party has submitted testimony or evidence in the form of writing prior to this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. If anyone from the public will then have an opportunity to speak after the applicant has presented its case. I'll give our zoning plans examiner, Doug Owen, an opportunity to provide any testimony that you would like. In the event that any party testifies or offers argument in opposition to this application, the applicant shall have an opportunity to rebut that testimony and or argument. The applicant will then have an opportunity to make a closing statement. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. I may also refuse to consider hearsay. This is generally just testimony you'd like to offer that consists of statements made by someone who's not present. In the event of any technical difficulties or unforeseen circumstances, I may continue or postpone this hearing at my discretion. All right, anyone who intends on testifying, making any comments, asking any questions, doing anything other than just strictly observing at this hearing needs to be sworn in. So I'm going to do that now for everyone. So if you intend to provide any comments, if you could make sure that you're off mute and raise your right hand. I need everyone to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. Thanks, everyone. Let's go ahead and get started. Mr. Papademos, are you ready?
Yes.
Okay, the floor is yours.
So, so you would like me to start like the brand new case you mentioned, or to catch up where we were left last time?
Yeah, I'd like you to start as if we were brand new. This is a brand new application, substantive. Okay. Thanks.
So we were proposing a single family residence on Mount Adams. Can everybody hear me okay? I know last time we had a little bit of an issue.
It's a little soft, but I think as long as you speak up, it should be fine.
Okay. So we're proposing a single family residence for our client. It's a 5-bedroom house in Mount Adams and 495 Baum Street. The applicant unfortunately couldn't, the owner couldn't make it because they're traveling with the family. So I'm representing them. And what I have talked with the zoning people so far, civil engineers, structural engineers, and even that, although I have a lot of information to share with the group, so I will be open for questions. But the single family residence we were proposing was had the 2-car garage in the front on Baum Street, and originally we had another set of 2-car garage on the back, on the rear of the house, that it was going to be access from the monastery all the way down. And based on some recommendations we got from Mr. Vogel and a couple of other people from the committee that they were last time, they were opposed to that. So after we did a little bit more investigation with the ODOT, I talked with Susan Enders. She was responsible for giving me all the information on ODOT. And after we talking with her a little bit further, although she mentioned to me that we could have the we could have a garage and a driveway going over the property, it needed to be certain materials that after talking a little bit with some people in the zoning department, they told me that most likely they will not be acceptable and it will be an uphill battle with the Mount Adams community. So as a respect for the Mount Adams community and also some of the comments that they had, we decided to totally eliminate that lower level garage. So that item is out. A couple of the other items have to do mostly with the zoning variances that we're requesting a little bit of the relief. And then after talking with the Walter from the last meeting, the zoning department were in approval of what we were asking. They made the recommendations, but at the same time, I know Mr. Bogle and a couple of other people from the group, or from the, actually there was one lady neighbor that lives diagonally across from our proposed site, had an objection on it would limit some of her views to downtown. I think another comment Mr. Vogel in the group had, and I apologize if I mispronounce your last name, Mr. Vogel.
Mr. Papademos, you're doing very well.
Okay, thank you. There was a comment, I believe there was a comment on the height of the retaining walls or the front wall of the building as it sits on the Baum Street. The experience the Baum Street residents had with the metropolitan group that constructed those houses on the upper side of the hill. There were some not so efficient engineering that took place, and I'm sure everybody remembers that there were some challenges, even some corrosion of the grade, and ended up requiring a lot of additional structure. Everything was secure, and everything is moving forward for now. Mr. Vogel and his group, I believe, they had some concerns about that, and that's why I believe they were a little bit opposed on or concerned, I should say, about the height of that retaining wall we have in the front. The rest, how much, this is a little bit of a summary, if you like, of what we talked about, what it is that we're proposing. I wasn't really sure how much you want me to get in depth with the actual building or anything else, or should I just open it for questions, concerns?
Yeah, so it's typically up to you how much you want to share. I mean, some of the ultra technical details may not be necessary, but in particular, why you think this requested zoning relief is appropriate based on the hillside standards. That's typically what's most useful for me. But in general, if you want to tell me why you believe this request is appropriate and it fits the standards in the code, that'd be great.
In some of the setback relief that we're asking, it's semi-normal for Mount Adams, for the Mount Adams neighborhood. With exception a little bit of the retaining wall and the depth of it, that we're asking a little bit of relief on that. But at the same time, from a structure point of view, that it was a concern from Mr. Vogel and the group. We have engaged the Civil Solutions group that have done a lot of work up in Mount Adams. We talked to the soil and structural engineer, and they have engineered the project much more complicated, much more secure than any of the metropolitan houses up there, as a way of making sure, as much as we can possibly make sure that the house is not going to slide down the street, but also the street is not going to slide down the road. As far as the relief that we're asking on the front setback and on the rear setback, those are in our mind is what it will make the house without exceeding or doing anything dramatic, still within kind of the limits that some of the other homes that we have done in Mount Adams will asking for similar relief. We're not asking for anything that is totally crazy, let's say, but everything in our relief is kind of a normal. And I think that's all I wanted to say. I can open it up for questions if that's a little bit more helpful.
Okay. So I'm going to go ahead and give the rest of the folks an opportunity to add some testimony, and then we'll go from there. So, Mr. Vogel, anything you'd like to add?
Well, if I could take up Mr. Papademos on his offer, ask one question. What is the square footage of this house as designed?
Will you allow me to do some math really quick? I thought I had it over here, but I do not have it in front of me.
No, certainly. And then just following up, Mr. Papademos, how many living floors are to be used here? When I say living, it's not just bedroom floors, but habitation, utilization, dens. I'm told there's a swimming pool. I don't know where that is on the design. So how many levels of use are the occupants intended to have here?
Yes. So the top floor, which is the second floor, is going to be full bedrooms. It's going to be 4 bedrooms. The main level, which is the street level from Baum Street, is going to have 1 office, 1 bedroom, kitchen, living room, breakfast room area, and the basement. It's a full basement that will have a family area that opens up to the exterior for the small pool. It's going to have a home theater media room right below the 2-car garage, and kind of a bar entertaining area on that level.
So that's 4 levels of various use, correct?
3.
3. So the second floor, ground floor, and then lower level floor. The lower level is the one that you're saying has the den and bar and all, and then that goes out to the pool?
That is the lower level, correct? That goes to the pool. Below, now, there is one more livable space that originally we had at the lower level garage that we took out, but since we took out that lower, let's call it sub-level, if you can.
Okay.
That sub-level, we took out the garage, and instead of filling it with gravel or anything like that, we're going to make another kind of a recreation area. Billiards, kind of a family room as well.
Okay, so that's 4 levels then of use.
Correct.
I would be interested in the square footage, but I can just while you're doing that, I can make a position for the record to Mr. Sturkey. He's aware of what I'm going to say. Again, we filed a letter that lists our position and objections, and I'm not going to belabor going through that. So I just wanted to recognize that's accepted into the record. Is that what I understand it?
Yes, absolutely. It's a part of the record. I received it late yesterday as a forward from Cassandra, and so that will be uploaded to Project Docs as a part of the record. But it may, since Mr. Papademos has not had a chance to see that or respond to it, it may be worthwhile for you to at least summarize or outline your objections on the basis of your objections.
Well, again, for the record, on a technical legal point, our objections are being focused on what we are told is the standard and the limitations for review of this particular application. which does not have the provisions of 1445, put parking that. We were told, we understand from the staff report that we're to look at the provisions of -23 as the hillside development standards in which to evaluate the relief, we would argue variances that are being asked for here. But so we're looking at -23, 1433 as the governing standards that the administrators and the zoning hearing examiner are instructed by the law department to look at. And as I said, there are 8 standards that are set forth in 23. 4 of them are expressly violated by the setback and excavation requirements. And then the other 4 of -23 are inapplicable, 2 of which concern the brow of the house or the brow of the hill below that. So we are again concerned about, and this was the same as before, the excavation, which is a significant variance here of excavation and fill of 21 feet. And then we have a setback, rear setback variance of 16, extraordinary. I would also, Mr. Sturkey, refer to the page 2 of Mr. Owen's staff report. There's a picture of the monastery lots facing monastery that the setback, the rear setback is limited to off of monastery of 20 feet. This proposal wants to go into that setback in a very significant way. And if you will notice that photograph, it is a complete greensward on Monastery from Baum Street at the corner, extending down the hill, and as Monastery then descends into the basin. So the setback that's asked here, and it's for, now instead of a garage, it's for a podium for a pool and the family playroom, etc. That's going to extend very significantly into that greensward. And eventually, of course, if this one goes in, the setback requests for the additional property owners will certainly be entertained by the city. And so we're going to lose that greensward. And that's one of the provisions of the hillside standards in 23, is preserving those types of areas, which the current zoning code does protect because of the setback requirements. So it's not a coincidence that there's nothing built on there, because they were unable to build on there because of the setback requirements. So that is our objection with respect to the setback. The excavation we are objecting to. Point that to be noted is that this particular building site, again, was the original proposals were coming in from Metropolitan Housing. They built the homes on the other side of the street on Baum Street, and those are the homes that were severely impacted by the landslide that occurred 4 years ago, and which again is part of the lawsuit that the city of Cincinnati has brought against now the receivers for Metropolitan Homes. Excavation, retaining walls, right there on this area, and so that's the basis for our objections. Excessive variance for excavation and fill, and then again a very excessive variation to allow the going into the setback of that greenwards area on Monastery.
Gotcha. Okay. And did you say that there were, you believe that the application violates or contradicts four of the 8 hillside development standards? Is that
Yes.
right?
Yes. B, 23B, design buildings to fit into the hillside rather than altering the hillside to fit the buildings. Hillside development should be designed to minimize excavation required for foundations, parking, and access drives. Minimize. This is not minimizing. Site buildings so that they respect views from public viewing places. That is my point about the greensward area on Monastery, which is shown in the photograph on page 2 of Mr. Owen's report. And then G, where applicable, consider the guidelines of the Cincinnati Hillside Development Guidelines, which again parrot particularly the ones that I'm quoting at B and C, which is to design buildings that fit the hillside rather than altering the hillside to allow a building to go there. And then should be designed to minimize excavation. those are all picked up, of course, and they find their foundation for the code in the hillside development guidelines, which were developed starting in 1969. So these are not unusual or new provisions, but they have guided the enforcement of development in the hillside districts, because the city for decades in the community has recognized the importance and uniqueness of the hillsides in the city of Cincinnati. And that again is in the zoning code, it's in the hillside development standards that are referred to in G. So, and there's nothing in -23 that that is allowed here. As I said, 2 of them are inapplicable because they're dealing with, you can't build buildings on the brow of the hill. So it's not 4 out of 8 doesn't mean that they meet 4. 4 out of 8 and they don't meet anything else. There's a point here.
Gotcha. Okay. To just follow up on one of your points, the views will be obstructed from public viewing areas.
As you come down Monastery, yes. That street rounds the hill and then descends down to the viaduct, Columbia Parkway Viaduct. This is Monastery comes up to Monastery is one of the entrance streets into Mount Adams. Elsinore is another, and then Martin Drive on the Ohio side. As you come up or you come down Monastery, you are confronted with the green path that allows and overlooks the basin. So that building is going to, as you come down the hill, is going to be immediately sticking out into the greens area there. And the setback is there. The 20-foot setback is what the city has required. It is, again, not a coincidence that there are no buildings on this, because they cannot build onto it because of the setback. Now, there is nothing of particular significance that would prohibit Mr. Papademos from building a very nice, grand house that fronts onto Baum Street. As I've quoted in my letter, the zoning hearing examiner's comments on the 2018 aspect of this was that it's nice to have a flat outdoor patio area, such an amenity. The patio area here now is going to be a swimming pool. So let's just quote this. While it is nice, excuse me a second, I'm sorry about that. While it is nice to have a flat outdoor patio area on which we're going to put a swimming pool, such an amenity is unfortunately not possible in every district, nor does it fit the character of every neighborhood. This is especially true in hillside districts where builders and owners are often constrained by the topography of their properties. And that's my objection to Mr. Owens' approach to this, which is this building can't be constructed under the code because it requires the change of the topography. So essentially, we take a position, well, the building can't be built under the application of the hillside ordinance, so we're going to have to change the way we enforce the hillside ordinance to allow the building to be constructed. That is topsy-turvy for what's intended here. And again, the zoning hearing examiner in that statement I've quoted in my letter and just read recognizes that fact. Of course, the code prohibits certain developments if those developments are in violation of the provisions of the code. That does not authorize a relief to be granted from the statute.
Okay. But you're not suggesting that the enforcement of the code has changed in order to necessitate the construction of this home, are you?
I'm saying that yes, the enforcement of the code is to allow this construction is a change in circumstance, and I can say nothing more succinctly than to point you to the decision of your predecessor, which was that I just read it, which is some developments are not possible because of the zoning code. That is the essence of that statement.
Do you mind providing the case caption on that?
No, I did. It's from the zoning hearing examiner's decision in this matter on February 23rd, 2018. This is the third iteration of a
Right.
building trying to go up on this. 2018, yes, there was a allowance with limitations, but then they were unable to build because they could not get permission from Ohio Department of Transportation. And I remarked to that when we first had this hearing, on the first hearing, was asking, do we, and this time, have approval from ODOT? Because the tunnels, there are a series of tunnels that are necessary for the retaining wall above I-71 that is restraining the hillside. This was the infamous, when 71 was constructed and the hillside slipped into the construction area. And we're all aware of what this retaining wall is, a very huge retaining wall that's administered by ODOT. And there are access tunnels that are necessary to access it. The other thing, and you can see it, is that there's an air shaft. And again, in the photograph on page 2 of the Monastery Street frontage here, the access for that air shaft is clearly shown in the picture. So I don't know whether we have approval for this design from Mr. Papademos from ODOT, or whether we're now asking to actually get the approval, and then we'll go back to ODOT and say, look, we've got the approval from the city of Cincinnati.
Gotcha. Okay. Cool. I want to make sure that I had a few of those things clear. And you know, I will note as I look through this decision from 2018 from my predecessor that there is no variance standard review. So this, at least since 2018, has been the standard under which we have been applying all hillside applications, not something more recent.
I'll have to respectfully disagree with that, because I've been subject to other of the applications that have gone forward, and they have. We can debate this and bore the rest of the people on this, but there's nothing in the appendant to my letter, which is the zoning hearing examiner application for zoning relief form, and that is the form that has been used and is current for this one. And there is nothing in that package that does not require the 1445 standard review. There is a provision in there that requires an additional statement for Hillside District. But I do dispute the statement that what we're doing here now, and then there's no more graphic evidence of that, Mr. Sturkey, of a change, and that David Owen submitted his staff report and 2 years ago, and the one that we just saw for the first time on November 23rd is redacted. You can see the changes that are marked there against the original staff report. And we are told that those changes were because of the city's instructions to Mr. Owen, to be the legal department, I'm certain about that, of course, to change that standard and to nix all of the analysis under 1445. So this record reflects the change in analysis.
Okay, I understand what you're saying. There was, and I will recognize that there was certainly, I believe, some disconnect between the zoning hearing examiner, the law department, their application of the hillside standards, and the standards that were making it into the staff report, which and that was across the board. That's not singling out anyone in the zoning department. But I think
I'm not criticizing Mr. Owen. I want to make that clear to him.
And that's what I was trying to make clear as well. But you know, what controls here is what's actually in the decisions, and what the decisions have been coming out with are just the application of the hillside standards. And as I look through the attachments to your letter, which is our application, I don't see anywhere where it says that the instructions for requesting development permission in hillside overlay districts is in addition to variance standards. Does it say that anywhere in there?
It doesn't say anything about any of the additional ones also. I mean, this is the form that, this form has been used and continues to be used. So you have instructions for applications requesting development permission in hillside overlay districts. And then the next sheet, instructions for applications requesting development permission in urban design overlay district. Are you taking the position, zoning hearing examiner, that when you have a application for development permission in an urban design overlay district, that it's only the one paragraph on this additional sheet? Is that the law department's interpretation now? Because this is not the way this has been done before.
Mr. Vogel, all that I'm saying here today is that the approach that we take to looking at hillside development standards and hillside development projects is to simply limit the evaluation to those hillside development standards. And that is explicitly clear, unlike your comment a moment ago, which was actually, on its face, not factual.
No, you and I, Mr. Sturkey, I'm respecting your position, but I am stating for the record that what you are stating is incorrect, and there is nothing more graphic to demonstrate the incorrectness of your statement than Mr. Owen's original staff report of 2 years ago, which does go through the 1445 standards.
What I'm saying here is that the zoning staff was using those additional standards in their staff report, but the decisions going back to at least 2018 relied only on the hillside development standards. And in our application, the instructions are clear that you only need to provide an explanation for why it's appropriate as in regards to the hillside development standards. And nowhere does it say in those instructions that the hillside development standards are in addition to the variance standards. You stated that earlier. This is a recorder, we can check it out. But you said that in our instructions, it's an addition. It doesn't say that. That's not the case. And this is how we've been applying it. This is how the ZBA has been applying it since at least 2018. This is how a magistrate in the Court of Common Pleas has just recently applied it. So that's
and I said about that. So you and I are arguing a decision that really is extraneous to what I've said, and will recognize for purposes of this hearing that we will analyze this on the basis of what you are now articulating. All right, we will do that. We will do that. If we will dispute, if we need to dispute the record. Well, no, and I'm not going to allow you not to allow me to make the statements to say that we disagree with that, because you don't cite us to any evidence of this at all.
Sure, you can disagree all you want, of course. That's perfectly reasonable.
That's all right. That's what I'm doing then.
Yeah, but I'm not going to let you say something that's not factually true on the record without correcting it.
No, what you're saying is that you don't believe what I'm saying is factually true.
No, I'm looking at it. Point to me where in our instructions it says that the hillside development standards are in addition to the variance standards.
You point me to where that has not applied previously.
I did. I sent you an email with a magistrate's decision after the ZBA said, after the zoning hearing examiner said it, the ZBA said it, and then a court of common pleas.
I read the record in the Glockerman case, and the provision that was adopted by the magistrate was articulated by Mr. Tidd without, as I've said in my letter, any authority cited. And the magistrate, on the basis of accepting this legal department, went ahead and put that in. But there was no authority cited, and it came from Mr. Tidd. It did not come from the defendant in there. Mr. Tidd, for the city, and that provision in Glockerman, when that was coming back up to the magistrate from the BZA, said that 23 is the governing standard, and that was accepted by the magistrate. I've looked at the briefs.
Okay. So what are we talking about here then?
Well, that's what I'm saying. Let's not debate. Let's not debate. I'm asking you then, you're telling me that 23 governs, and I say we accept that. So please, when we address the decision, I want the Mount Adams Civic Association is asking to see why the 4 points of 23 that I've identified do not restrict the application for relief of this particular applicant.
So let's jump back into that. You said that it affects views from public viewing areas. So, and you're saying that's because when you hit the intersection at Baum and
it's Baum and Monastery.
Baum and Monastery. There's a public viewing area there?
Yes, of course it is. Of course it is.
Is it from your car, you mean, as you're driving in your car?
It is, Mr. Sturkey, it is open to development right now. I'm sorry, it's open to viewing right now. There is no development on that entire strip of Monastery as it goes down the hill. That there has to be a reason for that. So you might differ on that one, but where then is the difference with respect to the restriction on unreasonable or excessive excavation, or the general provision that we design buildings to fit the hillside and not redesign the hillside to fit the building.
So let's ask Mr. Papademos that. Mr. Papademos, would you call this excavation or consider it excessive, or do you believe that this is the minimum excavation necessary to develop this property?
Yeah, I wanted to make a comment on that. The 21 feet that I don't believe it was Douglas that made that comment last time. It was the other zoning examiner. The 21 feet is not a straight cut vertically, meaning from a Baum Street, the foundation goes down 10 feet, 10 to 11 feet, then it goes horizontally straight towards Monastery, and then it goes another 10 to 11 feet when it reaches that preview. So it's a step down foundation. It's not a straight wall 21 feet up like the homes up on Baum Street. If that makes sense. So it's a step down foundation. It's not a 10 feet down, horizontally goes about 20 feet, and then another 10 feet down. And only on the garage portion, only what it used to be the garage portion. The main house is just the 10 feet of the foundation. So in our mind, if we cut a cross section, it's not excessive. It's if anything, we're trying to work with the side, not against the side. And that's why we were stepping the foundation accordingly. So to kind of try to work the best that we can with the side, not against it.
Okay, and so are you saying that there's a series of cuts into the hillside?
The hillside has one big cut in the front by Baum Street. That is the main portion of the house, the main front of the house, and even that it has a lot of vertical cuts within it, so it can provide more stability instead of just going straight foundation. And then that first itself, which is the lower level, it goes back another maybe 20 feet, and then it drops down another 10 feet to have an access to that sub-level. It's not that a lower level is not a 20 feet ceiling height, let's say. So does it make sense, or am I confusing?
I think that makes sense, what you're trying to say. Yeah.
It's not a straight foundation from the Baum Street going down 21 feet down to the basement. It's 10 feet vertically, then goes out horizontally, so we can walk with the side. And then after it reaches another kind of let's say midpoint where the side kind of starts sloping, we're dropping down 10 feet to have access to that sub-basement. So really, we're walking with the side. We're not excavating. It's not an excessive cut on the hill.
Okay. I've heard reference to a pool area several times now. Is that in the ground?
That portion of it is on the about half of it, a little more than close to half of it is in the ground, and then it drops down to the existing stone retaining wall that is at the almost parallel with the Monastery Street. So it is an in-ground swimming pool, and there will be a little bit of whatever fill would take out from excavating the main basin of the house. We're just going to taper towards the back of the pool to kind of a level, to provide a little bit more level area for the pool. Yes.
So how much of the excavation, or what portion, I'm sorry, how much of the excavation is in order to facilitate the in-ground pool in the rear?
That I would not be able to give you exact numbers, but whatever the one, a little less than 1/3 of the front of the excavation that we'll do to fit the lower level basement is going to be pushed back towards the swimming pool area to level it as much as we can.
Okay.
Would not filling the side, we're working with the side. And I know it's a little bit deceiving because of the verticals. It might be easier if we do cut some sections, maybe three-dimensional, to just see that we're working almost like a normal house that has a lower level, main level on a walkout basement. But also because of concerns of the street and what happened with the metropolitan group above, the front wall, we're making it having a lot of recesses and a lot of in and out, so it can provide additional stability instead of having a straight monolithic concrete wall. So it has a lot of in and out.
Okay. I recall last time the neighbor directly across the street was at the hearing and expressed concerns about the height. Have you changed anything in terms of the height between the last hearing and this hearing?
I had not yet. Based on the previous hearing, our biggest concern and topic for conversation was with the author, which whether we can do this building or not, and whether we can do the driveway or the driveway in the lower level garage, which after talking with others, they told us that the driveway, although it could be done, it needs to have different material, and that will totally eliminate it. But as far as the house, it does not encroach the 3D easement of the tunnel and everything that I have below. And for that we're good. I have not taken that in the letter back from Susan yet. I contacted her last week, but both her and the structural chief engineer were out. But I have requested a formal letter from them to submit to this group that says that the building is good. The building footprint is fine, but the driveway is most likely no. But they're preparing the letter. I have a verbal agreement, not a written yet. As soon as I get the letter, I will provide it to the group.
Okay, so you're saying that you may have a letter coming from that neighbor?
No, I'm sorry. I have a letter directly from ODOT that I'm sorry, I jumped a little bit going to one of Mr. Vogel's comments that we do have a permission from ODOT for the house. We do not have the permission for the driveway. But no, from the neighbor, I have not done anything for the neighbor to address the height.
Okay, got it.
Since last time, yeah.
Let's see. And there's no retaining wall relief requested for this project, correct?
They are building retaining walls.
It's the building retaining wall.
Are any of them above 8 feet?
It's a building retaining wall.
Okay. Anything else,
May I
Mr.
intervene? Can I intervene on that one?
Sure.
1433-19G. Excavation and fill should not exceed 8 feet in cumulative height. That's why we're here. So I take Mr. Papadamos's point, but we don't focus on each element of that foundation structure as it goes backwards. The cumulative aspects of it are what are to be measured under 1433-19 base development requirements. And so we have one here of 13 feet in excess of the base development standards. And so an issue here then is whether 13 feet is not deemed to be excessive under 1433-19G.
That's right. Yeah. Okay, Doug, do you want to jump in here?
So just clarification on that excavation, it's 21 feet total across the site. So that's basically measuring from the lowest point of the lowest cut on the hillside to the highest point where that cut begins at the highest point on the hillside. So the difference between that highest point and that lowest point is 21 feet, which is where the 13-foot hillside review comes from, because that 21 feet is 13 feet above the 8-foot limit. So it's not, there's no individual cut that we're talking about in this section. It's the cumulative cut across the site. So, you know, I will say that there is one individual cut that's approximately 12 to 13 feet in depth. And that's when you hit that first step, or the second step down on the foundation, which is basically the rear foundation wall along the back of the former garage, what's now the man cave area. So cumulatively, we're talking about 21 feet total from the lowest point to the highest point. You know, I don't think I have a whole lot more to add other than, you know, what is presented in the staff report, unless you have any specific questions.
Yeah, I don't think that I do right now, no. Let's see.
May I ask?
I'll refer to the staff report. Mr. Papadimos, go ahead.
May I ask one question on that? So if, just to make sure I understand this, if we totally eliminate that man cave like you referenced, and that is just a field, gravel field, instead of being a livable space, that helps on the excavation?
From my standpoint, I don't think that would drastically change the total cumulative amount. If you're eliminating, you know, some of the depth in that man cave area, you know, your lowest cut is still behind that point. So, you know, by shortening the depth of that man cave area, it would give you the opportunity to put possibly an additional step in the foundation, so that foundation is stepped a little bit more into the hill, but the total amount of cumulative excavation and fill would, I believe, would remain at that 21-foot number.
Okay. So, Mr. Papadimos, anything else in closing or otherwise that you wanted to share on this project?
Other than, I have met with Mr. Vogel on the site too. I really appreciate that you were there with me to kind of walk the site and totally understand all the comments and concerns. My office is up the hill, up on the Rookwood, the Pottery building, overlooking all those sites. So I know how steep some of those hills are, how secure or psychologically, mentally, everybody will feel. It's total understandable. We're trying to, as much as we possibly can, to create a home for a family that it's a little bit bigger than normal, just because the family is a little bit bigger. The work close by, they like it, and items like the pool, for example, might be excessive. If it at all helps, we can eliminate a couple of things within reason, just like the garage that we knew for sure that was nice, or a little bit like some people have expressed, and we realized that, and we took it out because they can live with the two-car garage, although it's a little bigger family. is then maybe a little bit with the height that I do not recall the ladies, the neighbor who had expressed a concern that they thought it was a little bit high, but so it's only at the house or metropolitan exceeding a little bit certain limits, which is fine. But we're willing to work with anything that is within reason and without creating. We don't want to create any issues or any arguments because I'm working in Mount Adam. I don't want anybody to be upset on me. The owners are living there. They have a business there also. So ultimately, we want to create something good for everyone. And we're open for any other suggestions that maybe we need to alter something that is without being too dramatic. Maybe we can still do, but that's all. That's all I wanted to do. I want to thank Mr. Vogel for representing everyone and telling all the comments. And I'm here to listen to what everyone from Mr. Starkey will have to say.
Okay. So I just want to make sure that I'm clear, Mr. Papademos, you're ready to submit this application for my review. You don't want any more time to discuss this with Mr. Vogel or the Mount Adams Civic Association before it goes onto my desk for official decision?
Can I open it up as a question because I'm not really sure on the legality of some of those items?
Yeah, you have a question?
Meaning that if it's I mean, if as a group, four of us see right now that there is something that it can be done to satisfy Mr. Vogel and the community point of view, I would be willing to sit down and talk with them. In the grand scheme of things, this with the changes that we have presented today are what they would like to have or as close. So if Mr. Owen and Mr. Starkey have some recommendations that they're not dramatically different, then I think we can continue. I can submit this to you. I'm sorry, I haven't done this so formal before, so.
Sure, that's fine. So I think you're saying that the changes that you presented today are going to be very close to what you'll ultimately need to submit at the end of the day, and that there may be some minor changes you'd be willing to consider, but they won't be dramatic. Is that a proper?
Correct. And the most dramatic will be even to, let's say, all that man cave that Mr. Owen reflected. Even that, I mean, we can eliminate if it helps.
So, Mr. Vogel, I'll give you an opportunity to weigh in here if you want to unmute. You don't have to, and I know you can only speak to a certain degree on behalf of the Mount Adams Civic Association, but do you think that that any further talks about design here would be worthwhile or would change the ultimate recommendation of the Mount Adams Civic Association?
I'd be happy to talk with Mr. Papademos. We've been consistent in the focus, and I think you'll recall, Mr. Papademos certainly recalls, is the extension of the rear of that building. If I could just ask one question, whether Mr. Papademos was able to compute what the square footage is for the house.
I'm sorry, I have not done that as I was trying to understand some of the legal comments you and Mr. Starkey were talking about that they got me a little bit confused. So I have not had a chance to do that yet.
Could I suggest, Mr. It must be in excess of 4,000 square feet.
Yes.
I just make that point again for the record that we're not trying to deny a person to be building a substantial residence on the hill. We are, and it's not of a particular difficulty that we're trying to impose on anyone. We're just again trying to continue to provide for sustained development of construction on the hillside in accordance with the zoning code as it has governed the development to date.
Okay. So, Mr. Papademas, I don't know if, like I said, I'm willing to give you more time to talk to Mr. Vogel, but if we submit today under the application that we have for review here, you know, I'll be granting the relief that's been requested today. Does that make sense? If you think that you may be able to address some of the issues that Non-Civic Association has with the design, then I can give you a little bit more time to speak with him and to make any potential alterations. Otherwise, we'll submit today on your request. And let me be clear, I'm not trying to push you in any direction here. I thought in your closing remarks that you had alluded to the fact that you would like to try to work with them some more. But if you'd like to submit today, that's perfectly fine.
May I ask you if we submit what we have today, and you make your decision, would that mean that you'll also make recommendations that instead of 3 feet, we need to go 2 feet, or instead of 20 feet vertical, we need to go 18 feet vertical, something like that? Is that how we work?
No, I typically won't do that. I will just grant an approval of the request or a denial of the request. Sometimes if I do an approval, I'll attach conditions to it, certain conditions, but I won't say, you know, you can have, you know, 9 feet instead of 13 feet for the excavation and fill. I won't do that.
Correct. I'm glad you mentioned that word, conditions. This is what I was looking for. You'll say, I approve this with those conditions, or disapprove this accordingly, correct?
Yes.
No, if that's the case, so let's say, at this point, we would like to submit the way we have it. Yes. And I'm sorry. And let's say, Mr. Vogel, do you think, considering that this is a big family, do you think it will make any difference if we talk any further about those setbacks, although those setbacks?
Mr. Papademas, let me be blunt.
Yeah.
The zoning hearing examiner has just told you that he's going to approve your request as submitted. So it would not be in your interest to talk with us any further.
Well, I think he mentioned that. I think he just said that he will approve for us to submit it, not that he will approve it. I think he's opening up for me and you in the neighborhood maybe to talk a little bit more.
Now, I heard Mr. Sturkey say that he is of a mind to grant the relief requested.
Mr. Papademas, I did not say that.
You didn't say that you were going to grant the relief requested?
I did not say that. I didn't say it. I said, if I do grant relief on here, I will not change the amount. So he's asking for 13 feet excavation and fill in addition, or 21 feet. I won't say, hey, you can do it, but it's only 15 feet. That's what I was saying I won't do. I was saying sometimes I will grant approvals and then I will attach conditions to them. There's a number of conditions that Doug has recommended here in terms of ODOT and some other things here. And so sometimes I'll attach those conditions, but I was merely talking in the abstract. I did not mean to suggest I was going to approve anything. And I certainly didn't say it explicitly.
Well, I apologize. I misunderstood you then. So I'm happy to meet with Mr. Papademas on that basis.
Yeah, and I think Mr. Papademas here is trying to ask you, is there going to be any wiggle room here? I mean, are you going to let a house be built here? Or are you going to support a house being built here? Or is this just a lot that you don't think is appropriate for development?
We've always said, and I said it here, that we're not trying to restrain the development of a house on this site. And we've been consistent in that provision. And as I also said, our focus has been the extension into the setback onto monastery. Very consistent in our position, and we will maintain that. We are not objecting to a house being built, and not objecting to a substantial residence being built.
So, Ms. Papademos, I think we've reached the point where I know it might not be abundantly clear what I'm asking you at this point, but I'm saying if you would like more time to try to meet with Mount Adams Civic Association, you're welcome to do that. Of course, you can submit today without any further discussion, and I will take what we have today and make a decision based off of that.
I would like to go ahead and submit what it is that we have. And I'm sure there will be some conditions or recommendations or maybe even denials. And at that point, I will take your recommendation, denials, and conditions. And at that, I think at that point it would be more appropriate for me to go back to Mr. Vogel and ask them, have one more talk with them.
Yeah, I encourage folks to continue to dialogue with community councils throughout their development process. So of course, you're welcome to do that as much as you would like. I will take this under submission. I think we'll leave it at that. And of course, Mr. Vogel, I'm happy to talk with you on the side or over the phone again, some more about those issues we were discussing earlier. I want to thank everyone for their time and their testimony here today. Ms. Papademos, I will, like I said, take this under review, conduct a site visit, and review the testimony from today, and I'll make a decision, and then I'll formalize that decision in a written opinion that I will send to everyone here via email in a PDF just moments after it's complete. That usually takes about 2 weeks. I know we're bumping up against the holidays, so there may be a little additional time that it may take. Mr. Papademos or Mr. Vogel, if you'd like an update on the status of that decision, please feel free to send me an email. But like I said, I'll include everyone here on that email once it is finished. Any other questions right now about any of that?
I want to thank you for allowing a robust debate, Mr. Sturkey. Thank you.
Well, as always, I appreciate it, Mr. Vogel. I really do. I enjoy that. Don't get too much of that in the ZHE role. So thank you. Makes me feel like I'm a litigator again. All right, great. Any questions come up in the meantime, guys, feel free to reach out to me. You have my contact. Thank you all. Hope you have a wonderful day, and we're adjourned.
Thank you.
Thank you so much.